have discussed the definition chapter and the only definition of evidence. And what is evidence, what can be evidence, what can be not a evidence, not an evidence, everything we have discussed. So the next definition which we are going to discuss, that is section number 2, class A, the definition of court. Okay. So court, the definition of court says that court means or court includes all the judges and magistrates and all the persons who are legally authorized to take evidence. Okay. So as yesterday we have discussed the definition of judicial proceeding. So in this it is written that judicial proceeding is a proceeding which is taken before the court in which the evidence is being taken on oath. So there we have heard the term court. And here the definition of court says court means the magistrates and all the judges and along with them all the persons who are legally authorized to take evidence. But there is an exception that an arbitrator is not a court. So that's why in arbitrator proceeding, Evidence Act is not accepted or Evidence Act is not applicable to a proceeding which is held before an arbitrator. Clear? So the court's definition says, in the first place, court includes all judges and magistrates and all the persons legally authorized to take evidence. And it does not include not an arbitrator. So when you are going to explain the judicial proceeding, you can also add there the definition of court. Okay. And then the next important definition is document. Not like important, we need to discuss each and every definition, but it is also important because the documentary evidence plays a very vital role in the suits and proceedings and cases. So document is also an important definition. So section 2D of BSA talks about document. So remember D for document, like E for evidence, D for document. So what is a document? So before I say, so document, the word document are being defined in various acts, like its definition is in BSA, in General Clauses Act, section 3 of General Clauses Act, in Indian Penal Code under section 29 document is defined. So there are multiple acts which defines document. Okay. So what is the document of the definition of document under BSA? Let's discuss. So in the first place, it is written that document is any matter. Okay. And the matter needs to be expressed or described. Either you are describing the matter on a page, on a as a painting, as a caricature, or you are writing on a wall. Everything can be a document. So either you are expressing or describing. So we basically express through painting, caricature, okay, like the handicrafts. So like the designs, not handicraft, the designs. By all those means we normally express, but we describe through letters, okay, numbers, figures, marks. So first, in the very first place, it is explained that document means any matter which is expressed or described. Okay. So now, if it is expressed or described, then on which substance it is being expressed or described? So upon any substance, whether it's a paper, it's a piece of cloth, it's a wall, it's a archive, it can be even any digital storage, whatever it may be. So upon any substance. Okay, then by what mean or by what it document is being expressed or described. So by means of letters, by means of figures, marks, or by more than one of those means. Either all these by all these ways, or by mixed version, or letters and marks, letters and numbers, letters and figures, marks and letters. So by means of all these things, or by more than one of those means. Okay, and what is the intention to like express all those things on that particular substance? That is important, and the intention to use this particular substance for the purpose of recording that matter. Okay, so the intention is being using. Understood this? Are you getting my point?
Yes, ma'am.
Is this clear? Okay. So, document means any matter. So, when we discuss about primary evidence, secondary evidence, under those chapters under proof, then the definition of document comes into play. So, it is any matter. First, any matter. Second, expressed or described. Upon any substance by means of letters, figures, marks, or by more than one of those means. Okay, and the last point is it is being intended to be used, or which is for the purpose of recording that matter. Okay, so here there is an interesting case which is Coca-Cola versus William Struthers Limited. So there is this is a case relating to or between two companies, and this is a Supreme Court decided case of 1968. So in this case, the Supreme Court has held that so we cannot limit the definition of document into pen, paper, describing, expressing, because nowadays with the technological development, we have to accept other such digital documents as documents also. So in this case, it is being decided that a tape recording can also be treated or admitted as a document. Okay, so here it is decided that a tape recording can also be admitted as a document. So this is the important case. So the
Ma'am,
case is
ଏଇଥିରେ ଯିବନି which is used for the purpose of recording the matter, tape recorder ଟା.
ବୁଝିପାରିଲିନି କଣ?
Ma'am, tape recorder भी तो ଏମିତି ହବ ନା कि used for the purpose of recording something.
Recording, but document definition हिसाब रे there must be substance. Okay, so ଏଠି କଣ ଏଇଠି जो process ଲେଖା ହେଇଛି ଏଟାକୁ ଜଣେ by like human କଣ ସେଟା କହନ୍ତି involvement ରେ ଏଇ ଜିନିଷ ଗୁଡା ହଉଥିବା ଦରକାର. but ଯେତେବେଳେ record କରୁଛେ ଆମେ କି ତମେ ଗୋଟେ CD ବନଉଛ କି ଗୋଟେ word file ବନଉଛ ହେଲା, ସେଟା ଗୋଟେ digital process ରେ ହଉଛି. ବୁଝି ହଉଛି? ତ previously କଣ ହଉଥିଲା ନା ସେ ସବୁ digital सब्सटेंस को डॉक्यूमेंट अंडर रे इंक्लूड करा जाऊ नथिला बट धीरे धीरे ताको एबे डॉक्यूमेंट अंडर रे इंक्लूड करा होछ काली जेमते मु डॉक्यूमेंटरी एविडेंस जतले पढौतली माने एविडेंस रे तले डेफिनेशन पढौतली तो बेसिकली डेफिनेशन से कम कहला दीटा प्रकार ओरल आउ डॉक्यूमेंटेड सो जो इंडियन एविडेंस एक्ट थिला जो तमे पूर्व एक्ट देखिबा बीएसआर एबे जहा डेफिनेशन देछि डॉक्यूमेंटरी एविडेंस रो इंडियन एविडेंस एक्ट भी सेम जिंस दिया हितला बट जो डिजिटल जो डॉक्यूमेंट कथा बा डिजिटल रिकॉर्ड कथा एटा परे अमेंडमेंट करा है कि तादरे इंसर्ट करा हितला जोटा कि बीएसआर एबे क्लियरली कंप्लीटली दिया हिछ तो प्रीवियसली का होतला ना डिजिटल रिकॉर्ड गुडा को डॉक्यूमेंट हिसाब रे एक्सेप्ट करा जाऊ नथिला तो धीरे धीरे केस लॉज रो डेवलपमेंट हला तापरे बहुत सारा अमेंडमेंट एक्ट आसिला जोथि कि डिजिटल एविडेंस को भी एक्सेप्ट करा गला जो डॉक्यूमेंट को भी रिकॉर्ड को भी एक्सेप्ट करा गला एज डॉक्यूमेंट्स एंड एविडेंस क्लियर हला
यस मैम मैम टिके इंटेंशन पार्टटा सेटा लिखि देबे इंटेंट माने सेटा बुझेई देबे आउ थरे
बुझो कुछ से कोची ये जो सब्सटेंस रे रिकॉर्ड करा होची बाय मीन्स ऑफ लेटर फिगर मार्क ए सब जिंस को आमे बनौचे गोटे डॉक्यूमेंट माने रिकॉर्ड बनौचे तार इंटेंशन कोन जोटा को कि फ्यूचर रे यूज करा जाय पारिबो ओके intended to be used in any like future time or which is used for the purpose of recording that matter माने यार आकु रिकॉर्ड करिवार रीजन कोन इंटेंशन कोन जे को हमें फ्यूचर रे यूज कर परिबा बुझेला
यस मैम
ओके एंड आउ गोटे इंपोर्टेंट जिंस एठी मन रख ए जो डॉक्यूमेंट रो डेफिनेशन अछि बीएसए अंडर रे आदरे गोटे छोटिया जिंस ऐड करा जो पॉइंट कि मु फास्ट कहि देबा कथा कि कि केस लटा
जो
माइंड
मैम
में
सुसाइड लेटर ताले एमती जीवो डॉक्यूमेंट रे
कोनटा को
सुसाइडल
जिंस
लेटर जो थाए
कोडा
मैम सुसाइडल लेटर जो थाए
हां हां ऑब्वियसली एटा कई डॉक्यूमेंट हबन तार तो से डॉक्यूमेंट हबार सबु जाक नेचर फुलफिल करूची कई हबन ताकू तो एक्सेप्ट करा जाए ना सेत पई एविडेंस रे बट सेथिरे कोन हुए ताकू प्रूव करा जिबा दरकार whether it is a like truly it is a substantive piece of evidence or not ताकू प्रकृत रे विक्टिम लिखिची कि आउ की ए जिंसडा लिखिची तार एग्जामिनेशन करा हबो ता माने कोन तार एग्जामिनेशन
यस
हबो
मैम
हैंड राइटिंग का हैला तो हैंड तमे आगु का
यस मैम
पढ़िबो से जिंस आसीनी हैंड राइटिंग को नेकिना भी बहुत सारा एक्सपर्ट्स आसीबे से एग्जामिन करिवे तार जो लोक लिखिची बोली कुहा होची धर मु कहूची जे सुसाइड नोट ना मोर गोटे सांग लिखिची तो वर्तमान जदि ता ऊपर काहर किछि क्वेश्चन अछि ताहले मो सांगर आउ किछि लेखा मु तांगु देखैबी से जो हैंड राइटिंग एक्सपर्ट जो माने थांती कैलिग्राफिक एक्सपर्ट से माने से हैंड राइटिंग को देखि किना माने ये करिवे जे डिसाइड करिवे जे वेदर ए सुसाइड नोट ता सेही लोक लिखिची कि नाही बहुत सारा जिंस अछि and the last thing जोटा कि एठी क्लियरली मेंशन करला जोटा तुमे भी पचाउथिला जे डॉक्यूमेंट भितरे इलेक्ट्रॉनिक रिकॉर्ड और डिजिटल रिकॉर्ड दीटा जक जिंस इंक्लूडेड ओके so document also includes according to the definition which is given under Bharatiya Sakshya Adhiniyama document also includes electronic and digital records जोटा कि इंडियन एविडेंस एक्ट रे एई डेफिनेशन ता नथि ओके एंड जदि बेयर एक्ट इलस्ट्रेशन देखिबो प्रोवाइडेड अछि जे ए राइटिंग इज अ डॉक्यूमेंट ओके वर्ड्स प्रिंटेड लिथोग्राफ photograph even a photograph is also a document okay inscription on a metal plate is a document ତମେ ଯୋଉ ଖଣ୍ଡଗିରି ଯାଉଛ ଉଦୟଗିରି ଯାଉଛ ସେଠି ସବୁ stone carving କରାହେଇକି ଲେଖା ହେଇଛି, engraved କରାହେଇକି ଲେଖା ହେଇଛି, those are also taken as a document. A caricature is a document. ଧର ଜଣେ କାର୍ଟୁନ ବନେଇକିନା ଯୋଉ ପେପର ରେ ସବୁ ଆସେ କାର୍ଟୁନ କର୍ଣ୍ଣର, ସେ ଯୋଉ କାର୍ଟୁନ କି କ୍ୟାରିକେଚର that is also a document. ଏବେ ନୂଆ ଗୋଟେ illustration add କରାହେଇଛି ବେସ୍ ଅଣ୍ଡରରେ, electronic record on emails, server logs, document on computer, laptop, smartphone messages, website, ଲୋକେସନାଲ ଏଭିଡେନ୍ସ କି ଗୋଟେ ଲୋକର ମାନେ ଫୋନ ର ଲୋକେସନ କୋଉ ଜାଗାରେ ଥିଲା ତାର ଯୋଉ ଏଭିଡେନ୍ସ, ଭଏସ ମେଲ ମେସେଜ, ଇଭେନ ତମେ ଯଦି ହ୍ୱାଟ୍ସଆପ ରେ ଜଣଙ୍କର ଭଏସ ରେକର୍ଡ କରୁଛ which is being recorded through digital devices, all are documents. ତ ମାନେ ଏବେ ଯୋଉ ଡକ୍ୟୁମେଣ୍ଟ ର ଯୋଉ
ସ୍କୋପ ଟା ୱାଇଡେନ୍
ସ୍କୋପ
ହେଇଯାଇଛି।
ଥିଲା, ହଁ ଯୋଉ ସ୍କୋପ ଥିଲା ତାକୁ ବହୁତ ହି ୱାଇଡେନ୍ କରାଯାଇଛି by the definition of base. ओके एज ऑलमोस्ट ऑल ସବୁ ଜିନିଷକୁ ଡକ୍ୟୁମେଣ୍ଟ ଭିତରେ ଇନକ୍ଲୁଡେଡ କରାହେଇଛି। ତ ଏବେ ଆଉ ସେ କୋକା କୋଲା ଭର୍ସେସ ୱିଲିୟମ କ୍ଲଦର୍ସ ଲିମିଟେଡ କମ୍ପାନୀରେ ଆଉ କିଛି ଏତେ ରେଲିଭାନ୍ସ ନାହିଁ। ଷ୍ଟିଲ୍ ମେ ବି ଏକ୍ସାମରେ ଆସିଯିବ, ତୁମେ ପଢିଦବ, କିନ୍ତୁ ଏବେ ଡକ୍ୟୁମେଣ୍ଟ କହିଲେ ଇଚ୍ ଆଣ୍ଡ ଏଭ୍ରିଥିଙ୍ଗ ଇଜ ଏ ଡକ୍ୟୁମେଣ୍ଟ। ଇଭେନ୍ ତମ ହ୍ୱାଟ୍ସଆପ ରେକର୍ଡିଂ ବି ଇଜ ଏ ଡକ୍ୟୁମେଣ୍ଟ, ତମ ହ୍ୱାଟ୍ସଆପ ର ମେସେଜ ବି ଗୋଟେ ଡକ୍ୟୁମେଣ୍ଟ, ଇମେଲ, other server log, everything which is stored in your devices, everything is a document. Okay, so this is all about the definition of document. तापरे जिबा हमें the next definition को, and आज आउ तीनटा important definition हमें पढ़िबा। First होची fact, तापरे होची fact in issue, and the third one is relevant fact. आउ ये तीनटा definition पढ़ी कि ना हमें क्लास को आज wind up करिया। So first definition हमारा कौन ना fact. Okay, and ये जो definition fact और definition इटा provide कराई चे section 2F. Okay, so F for fact. Okay, मन रहेगा easily F for fact. अच्छा, तो what is fact? So he एठी जो definition देची से लिखिला fact means and include. So एठी भी evidence रा definition भलिया fact को दीटा type रे divide कराई. Okay, so according to definition, facts are of two types. First type होची गोटे टाइप ऑफ फर्स्ट टाइप को कहउछंदी फिजिकल फैक्ट, आउ सेकंड टाइप ऑफ फैक्ट को कह जाउछे साइकोलॉजिकल फैक्ट. Okay, so let's understand what is a physical fact and what is a psychological fact. So the term physical fact and psychological fact is not there in the base. Okay, so why I am writing this? So whatever denotes there, that means only that. So the first category of thing which is provided that anything, any state of thing which is capable of perceived by the senses, those are called physical fact. So you are watching something, that is a physical fact. You are hearing a sound, that is a physical fact. You can smell certain fragrance, that is a physical fact. You could feel certain thing through your skin, either it is cold, it is hot, it is rainy, it is dry, it is whatever, the weather, the room, the temperature, everything is a physical fact. Okay, so physical fact means anything or state of thing which is perceived by the senses. So whatever senses a human being has, by the senses, whatever the human being senses, that is called physical fact. As I told, you watching something, you are hearing something, you are smelling something, you are feeling something, everything is a physical fact. Okay, understood? Please write down there. Okay, and the second fact according to the BSA is psychological fact. psychological fact means a mental condition of which a person is conscious. Okay, so here this particular thing is like difficult to understand. What do you mean by a mental condition? If someone asks you, what do you think about Narendra Modi? Okay, so you have a opinion. That is a psychological fact. If someone asks another person who does not like Narendra Modi, and that person may be the opposition, maybe Kunal Kamra, Dhruv Rathi, who are the biggest opposer of Narendra Modi, if you ask them what your opinion about Narendra Modi, so they have an opinion regarding that. Okay, so those things called psychological fact. So your opinion, intention, your act, whether it is in good faith or bad faith, okay, your like we can say your conscience or your motive to do certain thing, everything is a psychological fact. Is it clear?
Yes, ma'am.
Okay, and most importantly, your intention, your opinion,
Ma'am,
your
that
good,
need not be true.
sorry,
That need not be true.
means I don't understand what is the question.
मैम माने जहाँ भी ओपिनियन वगैरह सेटा एमती जरूरी ना कि सेटा ट्रू ही थिबा दरकार किछि भी
नहीं नहीं
ओपिनियन
नहीं एठी
फॉल्स
ट्रू फॉल्स कथा बिल्कुल भी आसुन हैला तमे कहबो मु आज राति 8 बेले गोटे लोक को एई जगह रे देखिली हैला तमे सत्य कहूछ मिछ कहूछ दैट इज अ डिफरेंट थिंग मु एबे फैक्ट कथा ही कहूछ जा फैक्ट डेफिनेट तमे जदी ए कथा कहूछ दिस इज अ फैक्ट तमे कहूछ मु देखी छी जनकू तमे से लोक को देखी था आउ जन को लिखी था कि तमे आउ जन को देखी कि ताकू मिसकनसेप्शन करके भाबु था कि तमे जानि सुनी मिछ कहू था दैट डज नॉट मैटर that is a state of thing where you are capable of perceived a particular the person through your eyesight, that is a fact. Okay, then
यस मैम
एठी हमें प्रूव करिया कथा ही होने हमें एबे खाली फैक्ट विषय ही कथा होछ तमने इंटर्नशिप जाउथिबो मु टिके आउ ए जिंस रो डेविएट करके आउ टिके आगु को जाउची तमे इंटर्नशिप जाउथिबो क हुई कोर्ट रे निजर कथा को सपोर्ट करिया पई कि लोक कम करंती फैक्ट गुडा को प्रोड्यूस करंती फैक्ट कहंती फैक्ट सहित एविडेंस भी दियंती एटसेट्रा सब जिंस करंती बट सब जिंस तादरो एक्सेप्टेड होय ना किछिटा कथा धर गोटे लोक आसी डिपोजिशन दोची विटनेस 50टा कथा कहला मु एई दिन एई टाइम रे एई इत्तिकी बेले बाहर को जाउथिली तापरे कहला मो सामने रे ए बिंगर झगड़ा हैला तर बहुत टाइम पर धीरे धीरे छोट छोट झगड़ा रू तंकर झगड़ा बहुत बढ़िला आ ए बी को स्टॉप कर देला वर्तमान जहा ये लोकटा कहला दैट इज ओनली फैक्ट ओके तो तापरे थ्रू द प्रोसीजर ऑफ द कोर्ट थेटा डिटरमाइन कराहबो से सत कहूची कि मिछ को अपोजिशन पार्टी पाखे राइट अच्छी से तुमको एग्जामिन करिवो तुमको लीडिंग क्वेश्चन पचारिबो तर तुम माने फिल्म सीरीज रे जम सब जिंस देखिथिबो कि बहुत लाइक क्वेश्चंस बहुत ही ट्विस्ट टर्न क्वेश्चन पचारिबो जम गोटे लोक को कंफ्यूज कर देबे जम से किछि भी गोटे मिसस्पेल कर देबो आउ संगे संगे जिंस प्रूफ हे जिवो ता अगेंस्ट रे तो ए जो जिंस उडा करंती तो से सब जिंस हे कि ना एंड रे जना पड़े वेदर सत कि मिछ बेले बेले सत कहउतबा कथा को भी कोर्ट रे मिछ प्रूव करि दिया जाय पारे तो आमे से स्टेज रे नै आमे खाली एया बुझुछु जे फैक्ट एक्चुअली कोन व्हाट इज फैक्ट बुझेला जिंस
यस मैम
सो जो साइकोलॉजिकल फैक्ट रे मुझे कहली ओपिनियन हे गला इंटेंशन हे गला like conduct hela in good faith or bona fide intention whatever fraudulent intention that mental like condition must be by a particular sense or at a particular time when the person is conscious that person has that okay तुमको पचरा जिबा कि तुमको मिस्टर ए केमती लागन तो तमे कहबो नै मो ओपिनियन ताको पई मिस्टर ए पई कि से बहुत ही क्रिप तर गोटे केस होची या मिस्टर ए विषय गोटे सुट सॉरी केस फाइल है जे मिस्टर ए तार गोटे एम्प्लॉय को सेक्सुअल हारासमेंट करछि ओके तमे जदि मिस्टर ए रो गोटे एम्प्लॉय हेतु तुमको विटनेस हिसाब रे डका कि तुमको मिस्टर ए केमति लागो तो तुमको ताठू जो भाई बसुव तुमको लागुव ना लोकटा बहुत क्रीप बहुत ही लाइक ग्लेयर लुक्स दिए तो जमती कथा हुए मते बहुत अनकंफर्टेबल फील करे तो सेटा होची तमर साइकोलॉजिकल फैक्ट अबाउट मिस्टर ए मे बी आउ गोटे लोक को डका है कि सेम क्वेश्चन पचरा से तार पूरा उल्टा कही पारे कि ना ना से तो बहुत फ्रेंडली से तो बहुत भल से बिहेव करती से तो एम्प्लॉइज मान को बहुत भल से ट्रीट करती तो आमर बहुत केयर नियंती एटसेट्रा एटसेट्रा सो से लोक भी जहाँ कहला दैट इज ऑल्सो साइकोलॉजिकल फैक्ट तुम्हें भी जहाँ कहो दैट इज ऑल्सो साइकोलॉजिकल फैक्ट सो साइकोलॉजिकल फैक्ट बेसिकली काइंड ऑफ ओपिनियन इंटेंशन like good faith fraudulent intention everything that is in a specified time when a person is conscious and it is about a particular sensation okay ebe clear hela bujhe hela
हाँ मैम
आउ कार किछ डाउट्स अछि लेख देन लेख ओके तो यार एग्जांपल ले लिखो ओपिनियन डिजायर इंटेंशन एक्सेट्रा okay so this
मैम
is
डिजायर
desire is also a psychological fact na?
नो एग्जांपल ऑफ डिजायर
देख डिजायर तमे तम लाइफ रे एबे किछि तमर एम थिबो कि मु बड़ हेले एया हबा को चाहूछि ओके सो that is a mental condition of yours and you are consciously taking the decision कि मु बड़ हेले एया हेबी so सेटा this is a kind of desire of yours हना नहीं
यस मैम
ହେଲା ଦେଖ ତମେ ଯୋଉ ପଏଣ୍ଟ ରେ ଇଏ ହଉଛ କନଫ୍ୟୁଜ ହଉଛ ମୁଁ ବୁଝେଇ ଦଉଛି ଗୋଟେ କେସ୍ ର ସିନାରିଓ ଭାବ ଗୋଟେ କେସ୍ ଚାଲିଛି ଆଣ୍ଡ ୱାଇଫ ଉପରେ ହଜବେଣ୍ଡ ର ମର୍ଡର କରିବାର ଚାର୍ଜ ଲାଗିଛି ଓକେ ସୋ ବର୍ତ୍ତମାନ ୱାଇଫ ର ଆଉ ଯେତେବେଳେ ଆମର କ୍ରିମିନାଲ କେସେସ୍ ରେ ଆମେ ମୋଟିଭ ଏକ୍ସଟାବ୍ଲିଶ କରୁ ଯୋଉ କେସେସ୍ ରେ ଆଇ ୱିଟନେସେସ୍ ନଥାନ୍ତି କେବଳ ସର୍କମଷ୍ଟାନ୍ସିଆଲ ଏଭିଡେନ୍ସ ଥାଏ ତା ଦେହରେ ଗୋଟେ ଲୋକର ମୋଟିଭ ଏକ୍ସଟାବ୍ଲିଶ ହୁଏ କାହିଁ ସେ ଲୋକ ମର୍ଡର କରିଛି କଣ ତାର ଏମିତି ବେନିଫିଟ ହେଇଥାନ୍ତା ଏ ଲୋକଟା ମରିଗଲେ ଯେ ତାର ମର୍ଡର କରିଛି ଓକେ ତ ଜଣେ ଲୋକ ଏଇଆ କହିପାରିବ ଯେ ସେ ୱାଇଫ ର ଆଉ ଗୋଟେ ଇଲିସିଟ୍ ରିଲେସନସିପ ଥିଲା ଗୋଟେ ଏକ୍ସଟ୍ରା ମ୍ୟାରିଟାଲ ଆଫେୟାର ଥିଲା ତ ତା ଡିଜାୟାର ଏଇଆ ଥିଲା ଯେ ମୋର ହଜବେଣ୍ଡ ମରିଗଲା ପରେ ମୁଁ ମୋର ଯୋଉ ସୋ କଲ୍ଡ ବୟଫ୍ରେଣ୍ଡ ଅଛି ବା ମୋର ଯୋଉ ଆଫେୟାର ଅଛି ମୁଁ ତା ସହିତ ମ୍ୟାରେଜ କରିବି ବୁଝିହଉଛି ଜିନିଷ
यस
so
मैम
that is a psychological fact obviously କାରଣ ତମେ ସେଟାକୁ ସେନ୍ସେସ୍ ଦ୍ୱାରା ନର୍ମାଲି ସେନ୍ସ କରିପାରିବନି ଡିଜାୟାର କୁ ଆଖିରେ ଦେଖିପାରିବନି कि ताको सुनी परिबनी एटाको फील करे जे परिबो थ्रू लाइक दैट इज अ मेंटल कंडीशन सो सेटाको हमें सर्कमस्टेंस रो ही कम करिया डिराइव करिया
यस मैम बुझिला
सो दैट इज डिजायर इज आल्सो अ साइकोलॉजिकल फैक्ट ओके I hope the fact portion is clear now so let's move to the next thing and the next definition is about fact in issue and it is there under section 2G. Okay. So fact in issue. What is fact in issue? So fact in issue in the Latin terminology of fact in issue is factum probandum. So factin issue basically a fact which is asserted by one party and denied by one party. So I have a certain fight with A. So now I filed a case against A. Okay. So I am saying that A has given the first slap, but A is saying that no, I am not given the first slap. The first slap is given by Sudipta. So factin issue is a fact which is is a fact which is asserted by one party and denied by another party. Okay, so here the definition says that, so factin issue is any fact from which either by itself or in connection with any other fact, the existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceeding. Okay, so whatever I have told in very brief, that is discussed in a very lengthy manner. So in factin issue, in a general meaning, we can say that the facts which is asserted by one party and denied by another. Okay, and in your moot courts, the issues you are going to frame or the issues you people are framed in the initial stage, that is called factin issue. You basically says it only issues, issue 1, issue 2, issue 3, those are fact in issues. So why the factin issues are required in a case or in a suit? Because these are those facts which the plaintiff, or in case of civil suit, in case of like in civil matter, the plaintiff, and the criminal matter, the prosecutor needs to prove to win, and the facts which the accused or defendant deny to succeed in some defense. Okay, so let's take an example to understand what is factin issue. So now A is an accused person and the accusation is A caused or A murdered B. The accusation is A murdered B. So at the trial, so three things need to be decided. The first thing is that whether A caused the B's death or the death of B, first thing. Second, whether A has intended to cause B's death, because sometimes the death or the murder might be caused through other circumstances. Maybe grave and sudden provocation is there. Maybe A just exceeded the right of private defense against B. Might be some certain exceptional circumstances must be there. So the second thing is whether A has the intention to cause B's death. And the last thing is whether, as I told you, whether there is certain exceptional situation is there, or like this is a planned thing. Okay, so whether A has received any kind of grave and sudden provocation from B. Okay, and the last thing, at the time of causing B's death, by what reason, or if like A is unsound enough that the grave and sudden provocation from B affected A so much that he causes B's death. So I am just putting some hypothetical situation might be there. So we are designing the issues. So here, to succeed from this matter, as a defendant, A has to deny all the factin issues, and the prosecutor or the victim needs to accept all the facts, that yes, this exists, third one also exists, fourth one also exists, and the accused is going to deny, no, I have not murdered B, first thing. Second, I have no intention to cause death of B. Third, if certain grave and certain provocation thing is there, then the the defense can ask for that. Yes, B was innocent. Sorry, A was innocent because B has first started fighting with A, has started quarreling with A, and has started abusing him. So that's why on under grave and sudden provocation, A just stabbed a knife into B's stomach. So this can be done. So basically, fact in issue are those facts which is asserted by one and denied by another. Okay. So is it clear?
Yes, ma'am.
Okay. So please write down, then we will discuss something else about fact in issue. So the definition says any fact either by itself look at the point third, fourth. Okay, so this is the definition of fact in issue. But the fact in issue plays different role in different proceedings. So in civil proceedings, the fact in issue plays a different role, and in criminal proceeding, the fact in issue plays a different role. Okay. So let's discuss that. So fact in issue in criminal proceeding. In criminal proceeding, the fact in issue is alleged by the prosecution and it is denied by the accused. Okay. Remember, it is alleged by the prosecution. Here, asserted by the prosecution is not written because the allegation are putting by the prosecution only, that the accused had did this, did that with the victim. Okay. So in criminal proceeding, the fact in issue is alleged by the prosecution and it is denied by the accused. And how the accused deny it? Anyone has any idea how the accused deny the fact in issue? By pleading not guilty. So you have read in sessions trial. So what the court
Yes.
asks the accused,
If you
are
plead
you
guilty
yes
or
or
yes, ma'am.
not? Yes, the accused pleads guilty or not guilty. So if the accused want to deny the allegations of the prosecution, the accused has to plead I am not guilty. So through plea of not guilty,
Trial proceeding begins.
yes. So that's why in criminal proceeding, remember, the fact in issue is alleged by the prosecution and denied by the accused person. Okay, but in civil cases what happens? It is asserted by the plaintiff. Okay, and then denied by the defendant. Okay, and in civil cases it is asserted by the plaintiff through plaint. Okay, and it is denied by the defendant through written statement. Clear? So the facts of plaintiffs are there in plaint and the facts of defendant is there in written statement. So
And allegation ଆଉ assertion ଭିତରେ difference?
allegation ଆଉ assertion ଭିତରେ difference ହଉଛି ଏଇଆ, assertion କରିବା ଆଗରୁ ତାର କିଛି primary inquiry investigation ହୁଏନି, but ଯେତେବେଳେ allegation ଲଗା ହୁଏ ତା ପୂର୍ବରୁ ଗୋଟେ investigation machinery ଅଛନ୍ତି ଯୋଉମାନେ କି investigate କରିକିନା ଜଣାନ୍ତି ଯେ ଏଇ ଜିନିଷ ହେଇଛି। ବୁଝିହେଲା? assertion ରେ clearly ତମର ଯୋଉ right violate ହେଇଛି କି ତମର claim ଯାହା ତମେ ସେଇଟା ଜଣେଇବ। allegation ଟା पूरा पूरी गोटे proper inquiry through रे जो जिनस जଣା पड़े ताको allegation कह।
Yes ma'am.
बुझिहेला माने प्रोसीजरल कथा कहूछ, बट ऑलमोस्ट सिमिलर जिनस हला, बट एया सिविल प्रोसीडिंग रे किछि इन्वेस्टिगेशन हुए। मते जणे कि मो प्रॉपर्टी रो डिस्पोजेस कर देला, मु सीधा सड़क लिखिबी कि मते मो प्रॉपर्टी रो डिस्पोजेस कर देछि डिफेंडेंट हला, किंतु मत मोर मते जदि के मर्डर कर देला मु डायरेक्ट जाय कि कोर्ट रे केस कर परिबी कि? मर्डर में मु कोछ अलगा ऑफेंस मते जणे थापड़ मारला मु जाय कि डायरेक्ट थापड़ केस रे भी करि हो कारण नॉन कॉग्निटिबल मो घर के चोरी कर देला हला, तमे डायरेक्टली जाय कि कोर्ट रे केस कर दबो, केस फाइल कर दबो।
Yes ma'am, FIR तो करिवो।
तो एफआईआर करिवो ना, तमे डायरेक्टली कोर्ट को पाखु जाय परिबो कि?
ना, मजिस्ट्रेट को बाय कंप्लेंट देई हबो।
सही कथा, तमरा जदि के तमको तम सिविल प्रॉपर्टी रु बाहर कर देला, तम सिविल को तम प्रॉपर्टी रु बाहर करला, तमे सीधा सिविल कोर्ट पाखु जिवो, प्लेंट दबो कि मोर ए आया राइट मतलब ब्रीच हेछि, मते रिलीफ दिया जो, मोर कॉज ऑफ एक्शन एया मते दिया जो हला। तो तमरा जदि क्राइम हबो तम अगेंस्ट रे, तमर की जिंस चोरी कर दबो, तमे का कोठी की जिवो, आगे कोठी की जिवो?
मैम क्राइम हेले
तम अगेंस्ट तम घरु गोटे जिंस चोरी होला कि तम बैग रु कोडे मोबाइल ले गेला, तमे आगे कहा पाखु को जिवो टू
पुलिस
सीक
स्टेशन
हेल्प?
पुलिस स्टेशन
बस
FIR
से कथा मु कहू, तमे सीधा सड़क कोर्ट को पळेइबो कि केस फाइल करिया पे कि बी मोर मोबाइल फोन नै लीछि करि परिबो कि से जिंस?
नहीं मैम।
बस सेही कथा मु पचारुछि, बिकॉज क्रिमिनल केसेस रे आगे गोटे इन्वेस्टिगेशन तमर सस्पिशियन जा ऊपर अछि तमे सेटा पुलिस आगे कर परिबो कि मते लागुछि मो फोनटा बी नै थाई पारे, किंतु ताबरे इन्वेस्टिगेशन हबो। बिना इन्वेस्टिगेशन न तमे कोर्ट को जाई कहबो बी मोर फोन नै जाईछि, मो केसटा रखंतु कोर्ट रे केबे भेले कोनोसी प्रोसीडिंग हबो नै, से तमु कहबो जे नै तमे पुलिस पाखु जा। बुझियो जिंस तो सेही गोटे होछि क्रिमिनल और सिविल प्रोसीडिंग रो डिफरेंस। एंड नेक्स्ट जिनस मन रख जोटा कि बहुत थर आमर एथिरे क्वेश्चन आसे, प्रिलिमिनरी क्वेश्चन ने पचारंती जे फैक्ट इन इश्यूटा सीपीसी आउ बीएनएसएस बा सीआरपीसी रे कोठी सिचुएट करबा को प्रोविजन रे अछि। ओके, सो सीपीसी अंडर रे ये प्रोवाइडेड अछि कोठी ऑर्डर नंबर 14 रे, अंडर द चैप्टर ऑफ फ्रेम ऑफ सूट। अच्छा, सो बीएनएसएस कोठी अछि ऑलरेडी तुम मैंने पढ़ी छ, under the chapter of charge. So in criminal cases charges are the fact in issue, remember that. सीपीसी वाला टा पिला ठीक कर दियंती, किंतु ये वाला जोटा हमरो बीएनएसएस वाला रे पिला माने कंफ्यूज होंती। तो चार्ज इज द फैक्ट इन इश्यू इन क्रिमिनल केसेस। ओके, तो चैप्टर टा टिके देखि दबो जो सेक्शन गुड़ाक मोटे मन ना सेक्शन सीआरपीसी रे अंडर सेक्शन 211 टू 223 चार्ज रो चैप्टर थिला बीएनएसएस रो सेक्शन टा टिके किए जदी देखि दबो संग संगे बेटर हो. So this is all about fact and issue. Is there any doubt? कार किसी doubt अछि? Okay, ठीक अछि. तो जिबा एबे next definition को. The next definition is relevant fact. Okay, and it is provided under section 2K. And the Latin terminology of relevant fact is factum probancia. Okay, so here fact in issue means factum probandum and relevant fact is factum probancia. So what is a relevant fact? So a fact is like said to be a relevant fact to another fact when the two facts are connected with each other in such a way that the provisions of BSA relating to relevancy of fact shall say it is a relevant fact. Okay. So there is a chapter under BSA that is that talks about relevancy of facts, and in that chapter it is provided which facts are relevant facts. There are rules. You don't have to judge anything, you don't have to inquire anything. So in that relevancy chapter, it is properly provided what facts are relevant, how relevancy is being established. So what is the definition of relevant fact? One fact is relevant to another when two are connected with each other through any of the ways which is referred under the chapter of the Adhiniyam as relevant facts. That's it, nothing else. Okay, and this relevant, the term relevant has derived from a Latin word called relevare. Okay, derived this term Latin word relevare, and relevare means legally pertinent, which means legally pertinent. Okay, and the definition says one fact is relevant to another when the two facts are connected with each other and secondly in any of the ways referred to under the provisions of BSA. Okay, this is the definition of relevance. So let me give you the sections from where to where relevancy of facts are explained. One second. Is It is there from section number 3 to section number 3 to section number 50. Okay. It is from section number 3 to section number 50. Chapter number 2. Under the chapter of relevancy of facts. So let me make you understand what is the basic difference, sorry, what is the like how we understand what are the relevant facts. Okay. So if there is a fact in issue that whether A stabbed B, and here there is like we can say no such thing or evidence is there by which we can establish there is no eyewitness, like this thing, there is no eyewitness, no one has seen them fighting, anything else, no one has seen them. So the question is whether A stabbed B. So what are the relevant facts to establish whether A stabbed B? Okay. So the first thing is A had bought a knife day before the stabbing or day before the death of B. A had bought a knife. Okay, and that can be established that whether the stab knife is the same knife or not. Then this fact becomes a relevant fact that A had bought a knife day before the death of B. Okay, there can be other facts that A had seen in B's building with a blood-shaded knife in his hand. Though people have not seen A stabbing B, but A had seen is in the building of B with a blood-shaded knife in his hand. That can be a relevant fact. Okay, and A and B had hostility between them before or prior the death of B. That can also be a relevant fact. Okay, are you getting my point?
Yes, ma'am.
Okay. So if I say, so these are the relevant facts to establish A stabbed B. But if I am on A's side, I want to defend A. So my answer will be no, A has not stabbed B. So what can be relevant fact of mine? So I can say the knife which A had bought day before B's death, that is for his personal use. So I have to prove that why A had bought a knife. Okay. Second, A and B had hostilities, but that does not mean A wants to kill B, because after B's death, A has no benefit or A has not got any benefit from death of B. I can show before the court that if B dies, A might have some loss. Maybe his promotion could not happen. Maybe something else could not happen. So after B's death, A might be in trouble. So A would not ever want to kill B. And third, the thing which is there that A had seen in B's building with a blood-shaded. Okay, so I can say that the stabbing had like happened as an accident. Just my mouse, that knife might be through any kind of accident, or I could not like articulate properly, but I can say that the stabbing might be become through any accidental process. Then A want to save B. That's why he put out the knife from his stomach. So then you have to establish those. Then only it can become a relevant fact. Okay, is it clear? Or is there any doubt?
No, ma'am.
So the last thing which we discussed today, that is the difference between fact in issue and relevant fact. Fact in issue and relevant fact. So fact in issue is determined by the court. Parties don't determine fact in issue. It is determined by the court. And those facts are determined by basing upon the fact of the suit or the proceeding during the stage of framing the issues or charges. Okay. So fact in issue, as I said, it is determined okay. So what is the relevant fact? So relevant fact is considered by the court. It is not determined. It is considered by the court to support or to deny the fact in issue during the trial of the suitor case. As I told, whether A stabbed B, it is a fact in issue. So if I want to support that fact in issue, so I have to say couple of things. If I don't want to support that thing, I have to say couple of facts, or I have to put not things to say, I have to put couple of facts. So the facts which are well established, that would be considered by the court, and those facts are regarded as relevant facts. Okay, so if the prosecution properly established that the knife which is bought by A one day before B's death, this is the same knife which is being stabbed to B. So that can become, and the accused could not defend the fact properly, that particular fact become a relevant fact. Okay. So relevant fact is considered by the court And the second difference between those two are, the first category of fact is, or the fact in issues are called principal fact, because this is the like core fact from which everything being started upon. And the secondly, the relevant facts are called evidentiary facts. Okay. In the next category, the third point, we can say fact in issue are those matters which are in the dispute. In dispute, not in dispute. And relevant facts are the foundations of inference. From those facts, we can infer things that yes, if B has bought a knife, sorry, A has bought a knife, that means A wants to kill B. And that knife was stabbed into B's stomach, that means A has intention to kill B, that's why he has bought a knife. So the relevant facts normally are those foundation stones of inferences. So these are foundations of inference. Okay. And fact in issue is asserted by one party and denied by another party. Asserted or alleged you can write by one party and denied by another. Okay. But the relevant facts are those facts which are produced by the parties to support what they are asserting or denying. As I explained to you, that if I want to prove before the court that yes, A stabbed B, so I have to pose couple of facts. If I want to prove A has not stabbed B, so I have to provide certain or a couple of facts. So these are the facts which is produced by the parties to support what they are asserting or denying. They are asserting or denying. Okay. And in the last difference, we have to write two examples from which the differences are much more clear. I have already discussed till I want to write those examples, so the things will be much more clearer. So, for example, so if A is an accused of murdering B, so the fact in issues are whether A has murdered B, whether A has intention to kill B, etc. are called fact in issue. But in the first issue or the question which whether A murdered B, the relevant facts are A is taking a plea of alibi that at the time of B's death, A was in a distant place. That is a relevant fact. And if this is being proved, that is a relevant fact. Okay. So, is it clear? If anyone has any doubt, please ask me. Not murdered, please write whether A killed B. Plea of alibi means elsewhere. Okay. So, when the parties plea that they are not at the crime scene or they are at a distant place, that is called plea of alibi. We will discuss it in the further provisions that is there in a very detailed manner. So, right now only know about that what is plea of alibi. So, alibi means you are at a distant place. So, that at the time of this death, he was in a distant place. Okay. So, is there any doubt regarding today's class? You can ask me. Then we will wind up today's section. So, there is no doubt. Great. So, please try to revise. Okay. I will sending you your notes till tonight. Okay. and please revise. Then if there is any doubt, please ask me. Okay, evidence is technical subject, so this is obvious if doubts are coming, so don't hesitate, please ask me anything. Okay, so the last thing, let's wind up today's session. Tomorrow's class will be from 8 to 9:30. Okay, so today is only some exceptional day, so that's why class is for 1 hour only. So, well, so tomorrow it happens to be the last demo class of everyday. Then from next Monday, you have to join. Okay, so let's wind up today's session. So thank you. Bye. Good night.
Thank you, ma'am.